New Zealand's revamped 3 strikes laws kicked in, targeting repeat offenders of serious violent and sexual crimes with increasingly tough penalties. The law covers 42 serious offences, including newly defined strangulation and suffocation charges. This version isn't quite as rigid as before. The amendments provide more judicial flexibility to avoid unfair outcomes, offer some leniency too for guilty pleas, and allow previous strike warnings to still count if they meet the updated thresholds. Supporters argue it's a much needed tool to keep dangerous repeat offenders off the streets and prioritise victims. However, critics warn the system can disproportionately affect Maori and Pacifica people, strip away judicial discretion and lack strong evidence for actually reducing crime. Associate Justice Minister Nicole McKee describes this as a central pillar in the Coalition Government's Law and Order program, and it's my pleasure to welcome her back onto the show. Hello, Nicole.
Good afternoon, Leah. Great to be back on with you and talking with you and your listeners.
Lovely to have you to talk again, Nicole. Can you explain, before we jump into how it all works, you've called this the government's central pillar when it comes to law and order. Can you explain that?
Yeah, look, this is really about making sure that there is the ability for us as government to set the boundaries and enforce those boundaries for law and order. And with the 3 strikes regime, it's really important that we do lock up people who are committing serious violent offences. And I think it's a timely reminder that a 3-strike regime is not for any offence. It's for those 42 offences that are serious violent or sexual offences. So when we hear critics say we don't necessarily know if this is going to stop people from committing crime, well, if they're in jail, they're not out there in our communities committing the crime. So I think that's a pretty good tell for us that if they're not out on the street, they're in prison and hopefully getting some rehabilitation while they're there.
Well, if we stay on that thread, Nicole, what about the, disproportionately affecting Maori and Pacifica?
Hey, to be fair, this is going to disproportionately affect those that commit the serious violent offences, full stop. And I don't really care what nationality or skin colour they are. They've got to get the message. We've had enough of this. Yep. Society has had enough of this. And I don't really care where you come from or what your background is. We all have to live here under the same rules and the same laws, and they need to get with the program or they'll get locked up. Simple as that.
Get with the program. Nicole, how does this 3 strikes law work? Can you give us a brief?
Yep. So we have 3 strikes. The first one, of course, will be a warning. So say you do something under those 42 offences. If that is imprisonable by 12 months or more, you will get a first warning. And that's basically, hey, you're on the strike regime. If you then commit another offence, you'll get a second strike. And that second strike means that you will get no parole for the sentence that you have, but also that 12 months lifts to 24 months. So you will only get a second strike should you get a sentence that's above 24 months imprisonment, but you're going to have to serve that full sentence. And when we get to the third strike, again, it's if you are imprisoned for above 24 months for one of those 42 offences, you will have to serve the maximum sentence that's available plus no parole. So that's effectively how the regime is going to work. And now under the previous 3 strikes regime, we had close to 16,000 people that were caught up in that or had been allocated strikes. Around 14,000 were first strikes. We had about 700 were second strikes, and there were 25 people serving a third strike. So we're not talking about a massive amount of people. We're talking about those serious violent offenders that continue to keep offending.
Strangulation and suffocation, new offences under the law, correct?
Correct, yes. They are seen again as being quite serious And there's a lot of it that's been happening, especially violence against women. It's happening against men as well, where they're being strangled or being suffocated. A lot of this actually happens in the sexual violence area, and so this is why we have added those to what was previously a list of 40 serious violent and sexual offences. It's now 42.
Right. How do the guilty plea discounts work under this law? And will they encourage early pleas?
We're hoping that it does encourage early pleas, and what it will do is allow the judge to then give a small discount to the perpetrator if they plead guilty, because what they're doing is stopping a victim from having to go through an entire court process. So if we can incentivise that so that people actually take responsibility for their bad actions and then get on with the consequences of it, and in doing so just give some relief to those victims of serious crime, then yes, they will get a very small discount on their sentence. But in saying that, under the sentencing reform that we've recently done as well, there is a cap on the amount of sentence reductions that can be offered to a criminal across the board, not just under 3 strikes. So really, we do want to incentivise guilty pleas. It means people take responsibility for their actions and victims are left to get on with recovery.
Yeah. What is that cap's 40%, Nicole? No, what's the cap?
The overall cap overall is 40%, but when it comes to 3 strikes, it's going to be, I think it's around a maximum of about 10% that they can be offered.
Wow. Oh, that's good though. That's judges.
Yeah, look, hey, if it helps the victims, it will be
absolutely. Judges have a little bit of wriggle room to avoid sentences that would be seen as manifestly unjust, especially on the 3rd strike. What does a manifestly unjust clause look like in practice?
This is really important that we put this in here, and that's because under the previous regime, we had an individual who had slapped somebody on the bottom, had been done for a strike. It was a 3rd strike and got maximum, and it was seen to be, just out of proportion to get the 3rd strike sentence for what he did. And in realising that, and this particular individual had some issues with mental health issues as well. So that's why we said we've got to have the ability for the judges to look on a case-by-case and see if there is a manifestly unjust scenario there. But in saying that, we've given them some guidelines as well. So, they have to look at that based on the guidelines because of the seriousness of even contemplating having a strike against you. I mean, we are looking again at those serious violence, serious sexual offences. So the judge needs to decide whether or not a slap on the bottom is just as bad as a rape, depending upon what case. So it allows them that little bit of judicial freedom within their court system. I mean, they are the ones hearing the cases. They're the ones that are seeing the victims and the perpetrators coming through. So we need to give them some little discretion, and that's why the manifestly unjust clause came in.